Sheila, I'd kind of like to start the fireside chat with, even in the Kahoot questions that we had a lot of discussions around GDPR. And in many ways, GDPR has been around for a couple of years, and I think is sort of setting the scene, if you like, for a global makeover of privacy regulations around the world. So, it's really been interesting to see how organizations have reacted to it, but how it's also sort of spawned a whole series of regulatory actions around the world, some of which are based on GDPR, some of which aren't. So, complicated cluster of questions here. So, if you take a look at the main themes of the New Zealand Privacy Act, how does it compare to GDPR, and how is it different than what New Zealand had in the 1993 regulations?
Great questions, and certainly pertinent to this topic. I would like to start by saying you're absolutely right that GDPR has spawned a tremendous growth in data privacy laws around the world. And in fact, GDPR is no longer the most restrictive data privacy law. It's the most visible and certainly the most talked about, but it is not the most restrictive. And South Korea's is much more restrictive, as is Japan's and certain other laws within the Asia Pacific region. But to get back to the New Zealand Privacy Act, part of the reason why John Edwards and the Parliament wanted to improve the Privacy Act in Australia is because, New Zealand, is because New Zealand was one of the first countries to actually obtain an adequacy rating from the EU, and that was under the old EU directive. So in order to be able to maintain that adequacy rating, which allows for the free flow of data between New Zealand and the EU, it was important to enhance the Privacy Act. Unfortunately, all of the recommendations of the Privacy Commissioner did not get approved by Parliament. And so although the Privacy Act is much more comprehensive than it was back in 1993, it doesn't really have the teeth that it's required to really meet the obligations under GDPR. So the adequacy rating is in question right now. It's being reviewed. It may lead to substantial changes in the Privacy Act again. It may also lead to having to enter into model contractual clauses or agreements in order to transfer data. But some of the key changes that we've seen within the Act, it has maintained a principle-based approach, which is very different than the GDPR. The GDPR is a very prescriptive or rules-based approach where it's very clear and obvious what you can and cannot do. A principle-based approach allows for more interpretation and flexibility in how you deal with the law and how you address certain issues. But some of the key changes, and probably the two most critical ones, is the first one is that the New Zealand Act is now what's called extraterritorial, which is based on the GDPR, meaning that if you process the personal data of a resident in New Zealand, even if you do not operate within New Zealand, you are bound by the obligations of the law. So if you have a website that caters to residents of New Zealand, you have to comply with the New Zealand Privacy Act. So that's one of the key features. Another one is the restrictions on what's called cross-border transfers. That's new within the New Zealand Act. And it's actually the IPP number 12. And what it says is that you cannot transfer the personal data of a New Zealand resident to an entity or to a legal body or to a person outside of New Zealand unless they can provide the same level of adequacy as is seen within the New Zealand Act, or you obtain the explicit consent of the individual, or you enter into what's called model contractual clauses. That's based very, very closely on the GDPR. And these are things that they basically looked at the GDPR and tried to incorporate as much as possible. Some of the other changes are things like the mandatory data breach reporting requirement. That's new. In the past, there hasn't been a mandatory requirement. It's been more of a voluntary requirement. It's similar to what both Australia and the EU require, in that if you have determined or suspect that you have a breach that could cause serious harm to an individual, you have to report it to the Privacy Commissioner as well as the impacted party. So that's new. Some of the other aspects that are new is that the privacy commissioner has been given more authority in terms of being able to investigate and to issue sanctions against individuals and organizations that violate the law. The negative part of that is that it doesn't have a lot of teeth to it. The maximum penalty that the privacy commissioner can basically levy on a company is 10,000 New Zealand dollars. That's pretty weak compared to the 4% of global annual turnover of the GDPR. Now, the other change is that the privacy commissioner, however, can recommend that the Human Rights Tribunal do an investigation of any type of violation of the privacy law. And in that case, the fine can be as much as 350,000 New Zealand dollars. Again, very small amounts in comparison to what you see with the GDPR, very, very small amounts. The privacy commissioner can issue what's called compliance notices, and that's when they determine that an organization has violated some of the aspects of the law. And the compliance issues notifications basically tell you what you can and what you cannot do. They do have enforcement behind them, but again, it's not really any type of sanction. Another area that has been added is that individuals do have the right to access their data, and they also have the right to have the data corrected. They do not have the right to have the data erased, which we see within GDPR. So it's not, again, it's not as restrictive as the privacy commissioner would have liked it to be. It doesn't meet all the requirements under the GDPR, but there's certainly some positive enhancements that have come out of it.